So it begs the question, well, what is famous? You know, and every country kind of sets their own different standard for that. In the U.S., especially because of the advent of domain names, a lot of trademark holders were using the dilution and tarnishment remedies to fight against domain registrations. And courts started seeing this very loosely, and they were granting this famous status to trademarks that really weren't famous. They were maybe famous within a particular niche industry, or maybe within a particular profession, but within the general consuming public, they definitely would not be considered famous. So that was a problem. The case law was starting to get very muddled and really murky for anybody to have good, predictable guidelines to try to make smart decisions. So luckily, last year they passed a new Dilution Act that basically sets a very firm standard on what famous is, and it's famous in the eyes of the general consuming public. And that's going to make it very difficult for most trademark holders to pull the dilution defense. Because even if you are, like, say, a famous detergent brand, that's not to say the general public knows who you are, or that they're going to instantly identify that company with that trademark. Now, the law wasn't all that great, in that while they made the standard for famous harder, they also made the other standards easier. So it used to be that you had to show actual dilution of a trademark, and that's such a ethereal concept, that how do you show actual dilution, And so under the new law, they just have to show what's called likelihood of dilution, and that can just, anybody can make that claim. That's a pretty easy standard. So once we, moving on to out of trademarks, we have some very similar kind of rights. Publicity rights, which can kind of be seen as, an individual's trademark rights in their name. And commercial use here is going to be the big factor again. And that if you're taking advantage of somebody's name for commercial purposes without their consent, it could infringe upon their publicity rights. That being said, if it's a public figure, they have opened themselves up to much more public discourse about them. But there's a difference between commenting and speaking about somebody and commercially using their likeness. You can kind of think of it in similar veins to when a celebrity has their photo taken and then somebody uses it in their marketing material without their permission, because it basically creates in the minds of the consumer an association between the two. And so that's with domain names, it's a kind of similar thing. Another related law is passing off. And passing off is very similar to trademark law, but it's the kind of the common law unfair competition version of it. With passing off, it's basically more of are you presenting yourself out as this company to confuse consumers on purpose? And there's been some famous cases, involving companies that have very descriptive trademarks, and then other companies who start up or use domain names that incorporate those descriptive trademarks, and then the company will come and make a passing off claim. Phones2go.co.uk was a very famous case on this, where it's phones to go. I mean, it's kind of a descriptive concept, but phones to go is a registered, fairly strong trademark in the UK, and they were able to shut down the use of domains that were incorporating that term being used to sell cell phones. And there the trademark infringement was difficult to show, but passing off was relatively easy, even though the defense there being that there was no intent to pass off, but if in the minds of the consumers they would confuse the two, that was good enough.
Just on that case, is that even if it was a .com, which was, they were trying to argue that it was American consumers typing a descriptive phrase,
yeah, I mean, it would be a very...
Particularly another country, it was unfortunate that people were typing...
Yeah, and those are important factors, and one of the things they're going to be looking at there is, was the website targeted to people in that region? Was it even though it was a .com, did it incorporate content that was specific to, say, a UK audience? So if we use a parking example, if it was phones2go.com and the keyword was UK cell phones, that little factor would be enough to say that it was targeted towards those consumers. So that's kind of a little number of some of the laws out there that have to be avoided. So kind of ask the question, how do we avoid these little problems? one of the best things to do is trademark searches. Knowing what is out there, knowing what the trademark is, who the holder is, where are they located, and what goods and services are associated with it. To kind of illustrate this point, one of the cases I talk about a lot is Elephant.com, which related to a UK insurance company who, Elephant Insurance, doesn't really make sense to me, but in that sense it would be a very strong trademark because it arbitrates. It has nothing to do, elephants have nothing to do with insurance. So it's a very strong identifier if they put the right marketing efforts into it. Well, the domain owner had elephant.com, and he had his own Google solution and had a picture of an elephant and then Google ads. His keyword was elephant. Well, it just turned out that the competitors of this insurance company were putting ads through Google based on the elephant keyword. So he had no role in those competing ads showing up on his domain name. But if he had gone in advance and say done some trademark searches and seen that, okay, elephant, this is an insurance company, I know for certain that I want to avoid insurance related keywords, then that would be a smart choice. Luckily for him, he did avoid any insurance keywords. He just had elephant, and the insurance company lost their UDRP case and their U.S. Court case when they tried to take the domain away from it. But it's important to think about those things because, especially when we're using parking solutions that use a lot of popular search records to kind of see what people are looking for, there might be that temptation to take some of those keywords that people are typing into the search bar, and to try to increase your CTR. But that would be, it's a temptation that should be avoided, because that's where you can take a legitimate domain that's being used legitimately, and you can cross the line into by that selection of keyword there.
I think the elephant one, he did avoid insurance ads.
Well, he avoided using insurance keywords, but he had no control over what ads Google is going to send him.
So he's only going to use elephant as a keyword. Doesn't matter if there's some insurance ads.
Yep, he won both the UDRP and the U.S. court case.
Wouldn't they argue though that the fact that he parked it and he chose to take ads, that he did have some sort of critical...
They tried to make that argument, and that's why it was such a great case, is that both under UDRP and in the U.S. courts, they basically acknowledged that his use of the domain was legitimate and should be protected. And that because they couldn't show an intent to profit from the trademark. It was elephant. His keyword was elephant. He had a picture of an elephant there. He wasn't going after the insurance company. But that's why we need to know what trademarks are associated with our generic domains, because it can be very easy and sometimes tempting to take a legitimate domain and do something silly with it. That you might make some short-term money, but it's going to give you long-term problems. Under the UDRP, they have to show bad faith at the time of registration, and so you might still be able to win a UDRP case with a generic domain under that kind of scenario, but under the ACPA or under a lot of the other kind of passing off kind of laws that are out there, it wouldn't be as relevant. Yes.
What if he had been not entirely passive, but he had, through his parking service, it said, run financial services areas on this page, where he had done, because you can do that in parking, you class an ad you like to be displayed on the site.
Yeah, that would have been
across the line.
Yeah, I mean, if he had gone out and classified his domain in a insurance category within the database, that to purposely draw ads associated to that would definitely be a problem. I mean, that's why when we have generic and descriptive domains, we need to keep them in the categories and associated with the keywords that are related to it, because as soon as we try to make that jump into because if you think about it, the trademark as a key, say if insurance would have been his keyword, maybe his CTR would have been higher. Maybe it really is the most relevant thing people are looking for when they type elephant.com into their browser. But that's the temptation that needs to be avoided. People do need to show restraint with their parking. And you want to have a high CTR, you want to have a high CPC, but you shouldn't kind of cross that line in order to get there. You'll still have a long-term profitability with a domain if you take the safe route, even if you'll miss out on some immediate